The Supreme Court has made a significant move by lifting the interim order that previously halted the removal of Rule 170 from the Drugs and Cosmetics Rules 1945. This rule specifically prohibited the advertisement of Ayurvedic, Siddha or Unani drugs. This directive instructed state governments to enforce the Drugs Magic Remedies Objectionable Advertisements Act 1954, which aims to curb misleading medical advertisements. And this is the part most people miss. The court's decision to lift the stay does not mean the issue is entirely resolved. The bench explicitly stated that parties with grievances related to the removal of Rule 170 can still seek legal recourse. This preserves the right for stakeholders to challenge the decision in future proceedings. The controversy began when the Ministry of AYUSH issued a notification on July 1, 2024, to amend the drugs rules by removing Rule 170. However, the Supreme Court stayed this notification on August 27, 2024, citing that it contradicted a May 7, 2024 order directing adherence to Rule 170. During the recent hearing, Advocate Archana Pathak Dave, representing the Union of India, requested the lifting of the stay. Amicus Curiae, Senior Advocate Shadan Farasat, opposed this, arguing that Rule 170 aligns Ayurvedic practices with allopathic standards and that states have already begun implementing the rule. Justice Vishwanathan questioned the practicality of enforcing the rule if it had been omitted, while Justice Nagarathna pointed out the inconsistency of allowing manufacture but prohibiting advertisement. Advocate Pranav Sachdeva, representing an intervener, emphasized the risks of unregulated advertising, particularly for vulnerable populations. People spend years chasing these remedies only to realize there is no cure, he argued. The bench ultimately concluded that those aggrieved by the notification can pursue their claims through appropriate legal channels. This decision reflects a balance between regulatory oversight and the rights of stakeholders, but it also leaves room for ongoing debate and potential legal challenges. Background: the case initially stemmed from the IMA's efforts to regulate medical advertisements by Patanjali Ayurved Limited. It later expanded to include contempt proceedings against Patanjali, its managing director Acharya Balkrishna, and co-founder Baba Ramdev for violating an undertaking not to publish misleading ads. In August 2023, the Ministry of AYUSH directed state licensing authorities not to enforce Rule 170, pending its proposed removal. Despite promising to withdraw this directive on May 7, 2024, the ministry issued the July 1, 2024 notification, leading to the August 27, 2024 stay. The case also involves the enforcement of the Drugs Magic Remedies Objectionable Advertisements Act 1954. On March 26, 2025, the Supreme Court issued comprehensive directives to state governments, including the appointment of gazetted officers, the creation of grievance redressal mechanisms, and police sensitization. The court highlighted the need for strict enforcement of the Act, warning of the potential harm caused by misleading advertisements. The contempt proceedings against Patanjali and IMA President Dr. R.V. Asakan were eventually closed after apologies were tendered and accepted. The case, titled Indian Medical Association versus Union of India, WPC number 645/2022, remains a critical example of the ongoing tension between traditional and modern medical practices in India. What do you think about the Supreme Court's decision? Should traditional medicines be allowed to advertise freely? Or do they need stricter regulations to protect consumers? Share your thoughts in the comments below.